Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, listen, Oregon folks, the clock is ticking because Oregon Ballot Measure 114, the measure that will essentially eliminate all of your Second Amendment rights, is set to become effective December 8th, 2022. That's right. That's just around the corner, an early Christmas present for you. So, has many of you in Oregon clamoring, what is going to be done to stop that? Well, I'm happy to announce that somebody has jumped in to try to save your Second Amendment rights. So, let's spend a few minutes today, let's geek out on it a little bit, and let's talk about, here comes the first lawsuit to stop Oregon Ballot Measure 114. Okay, so the issue we are talking about yet again is absolutely the worst piece of gun legislation ever passed in the history of the United States by any individual state, and that, of course, is Oregon Ballot Measure 114. Now, as we know, this measure does quite a few things, all of which designed to disarm lawful and responsible Oregon citizens. Well, I want to thank one of our loyal Oregon viewers, Jerome. You know who you are because he was kind enough to tip me off about that, and that is the first official lawsuit filed to stop Oregon Ballot Measure 114 from going into effect. Again, the effective date of this legislation is December 8th of 2022. It is right around the corner. The lawsuit is the Oregon Firearms Federation v. Brown, and there is multiple plaintiffs to this lawsuit and a couple of defendants, but the official title to this particular lawsuit is the Oregon Firearms Federation v. Brown. The case is filed in the United States District Court in Oregon in the Pendleton Division. Okay, let's get to know the three plaintiffs so far. The Oregon Firearms Federation, OFF, is a nonprofit 501c4 organization operating out of Clackamas County there in Oregon, and they have been doing tremendous work for a number of years, standing up for many civil rights, primarily those related to your Second Amendment rights. They are essentially representing all the citizens of Oregon. Now, there are two other plaintiffs, and I think we need to give kudos to these folks as well. The first is Sherman County Sheriff Brad Lowry. That's right, a county sheriff for Sherman County in the state of Oregon, God bless him, is one of the named plaintiffs against the governor in this. And then the third person is a private citizen, Adam Johnson. So collectively, these three plaintiffs are able to come at this issue from multiple different ways, from representing FFLs to representing lawful and responsible gun owners throughout Oregon to representing the law enforcement angle, both as how they enforce this law as well as the effect it has on law enforcement officers. Now, the Kampf Law Firm out of Portland, Oregon are the authors of this particular suit, and specifically Attorney John Kampf is the author of the pleadings. And if I'm mispronouncing the last name, John, I apologize. Please call me and make sure that we get it correct. Now, as far as the named plaintiffs, we're going to put links for all of them down below, OFF, as well as we'll put some information about Sheriff Lowry down there so you understand who the people are that are throwing their hat in the ring, that are picking this fight on behalf of each and every one of you. Now, I've had an opportunity to review the complaint, and it's very well drafted, and I love the way that plaintiffs are taking on this issue because this is a multi-pronged attack on Oregon Ballot Measure 114. It comes at it from many different ways, all of which I think has legitimate legal arguments and support behind them. Now, the first and obvious argument is, well, of course, it violates the Second Amendment, and it most certainly does. In addition to violating the federal constitutional right to keep and bear arms, Plaintiffs' Counsel is also arguing here that, hey, listen, it violates Oregon State Constitution, Article 1, Section 27 as well, and we'll geek out about that in just a moment. Now, in addition to that, and this is part of the argument that I really like, we've already done this video right here, which talks about how Oregon's magazine ban is actually quite a bit different than Washington's ban. And we have another, by the way, video coming out there where I've had a chance to geek on it a little bit more, and I actually think that Oregon's magazine ban is far, far worse than I even imagined to begin with, okay? So what Plaintiffs' Counsel is saying here is, hey, listen, you're basically rendering property which is lawfully owned by people illegal. They can no longer own this property, but they're not being compensated for it. And that is a violation of the constitutional takings clause part of the due process protections afforded American citizens. Now, in addition to that, there is a separate argument that this violates due process in another way, which we'll geek out on in a moment here. And then finally, and this is something that we pointed out in these videos right here, Plaintiffs' counsel is saying, hey, this also violates the Oregon State Constitution, specifically Article 11, Section 15, which deals with the fact that now there's this huge government program designed to provide services for the citizens, and there is not one iota of funding for any of it. Major problem. So just to give you kind of a flavor of these pleadings, and again, we will link the pleadings up for you down below so you can geek out on them yourself. But again, as it relates to the first attack on Ballot Measure 114, which is the fact that this is obviously on its face a violation of both the federal and state constitutional protections to keep and bear arms, Plaintiffs' counsel correctly points out 114 violates multiple constitutional provisions. First, it impermissibly burdens plaintiffs' Second Amendment rights. The Second Amendment protects the right to keep and bear arms typically possessed by law-abiding citizens for lawful purposes, citing to D.C. v. Heller. This applies to keeping and bearing arms both inside and outside the home, citing to Bruin. The standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify the regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. The Second and 14th Amendment protect an individual's right to carry a handgun for self-defense outside the home. The state's licensing regime violates the Constitution. Individual self-defense is the central component of the Second Amendment right. And again, citing to New York Pistol and Rifle Association v. Bruin, a case that Oregonians, you better get very, very familiar with. This is the case that is probably, in all likelihood, going to save the day for you. Now, as it relates to the state constitution, because remember, there's a federal challenge on the federal constitutional grounds. It violates Oregonians' Second Amendment rights. There's also a separate challenge here in the complaint, challenging this under the Oregon State Constitution as well. Plaintiffs' counsel frames that argument as, second, Article 1, Section 27 of the Oregon Constitution states in relevant part that, quote, the people shall have the right to bear arms for defense of themselves. The Second Amendment protects the purchase and use of ammunition and magazines necessary to make firearms effective. Because the magazines Oregon prohibits are, quote, in common use for lawful purposes like self-defense, the prohibition cannot stand. So that in general is the two constitutional attacks. But wait, there is more and a lot more. Because plaintiffs' counsel, and I think this is a really intelligent move, and for those of you who want to geek out a little bit on the takings clause, check out this video we did right here. Now, it's about bump stock cases. And as we know, bump stock challenges have happened in just about every circuit court, and every single circuit court has said that the Trump administration and the ATF had the lawful authority to prohibit and ban bump stocks. The case that we talked about in this video right here, however, is a case where the plaintiffs are saying, hey, you know what? Okay, fine. You guys get to ban the bump stocks. That's no problem. The thing is we all had money invested in this. And overnight, just like that, you made these illegal, which means you essentially took my property because you gave me two options, destroy it or turn it over to you. And that is a constitutional takings. That is when government seizes property from you under the color of law, such as this. You're entitled to just compensation. You see this a lot in eminent domain cases where government is trying to seize property for expansion of highways and off-ramps and things like that. The dispute is never going to be about whether or not the government gets the property. The dispute is going to be how much do they owe the property owner. So Oregon, the thing about your magazine ban, and again, we're going to be doing a second video about this, but in many ways, I believe that any magazine that you may have, which exceeds the 10-round minimum, you're not going to be able to really use in any way, shape, or form unless you have it in your own house. It basically renders these things meaningless, useless, okay? That is a takings, and none of you are going to be compensated by the Oregon state government for this. That is a violation of your due process rights. It's a very intelligent argument for plaintiffs' counsel to make. The next due process argument, because due process is a multifaceted protective scheme here, is that, listen, if you're all of a sudden going to turn people overnight into criminals for owning something that previously was completely legal, that is an ex post facto, or what we like to call a retroactive application of the law. That is not how it works. Presumably, any ex post facto retroactive application of a law which turns a person into a criminal based upon activity or possession does not apply to people who committed that act prior to the enactment of that law. If it does apply to them, that is an ex post facto violation of one's due process rights as guaranteed under the Fifth Amendment of the federal Constitution, and this is an excellent argument that plaintiffs' counsel is making. And then finally, and this is something that we noted about Oregon Ballot Measure 114 when we were geeking out on it to begin with, which is there was an incredible amount of cost for implementing this program, and yet there was not a single ounce of funding anywhere in it. Now, interestingly, as I started geeking out on the Oregon State Constitution, it turns out that perhaps for the ballot measures, that's not actually required. However, what plaintiffs' counsel is arguing here is the following. 114 also violates Article 11, Section 15 of the Oregon Constitution, which provides that, quote, when the legislative assembly or any state agency requires any local government to establish a new program or provide an increased level of service for an existing program, the state of Oregon shall appropriate and allocate to the local government money sufficient to pay the ongoing, usual, and reasonable cost of performing the mandated service or activity. And that is an excellent point, because there is estimated price tags that this is going to run somewhere around $50 million to implement, and then it's going to cost local law enforcement on average somewhere in the range of $7 to $9 million per year. There is not one iota of funding anywhere in this measure to allow local governments to do what the measure is mandating. Now, the biggest beef, and I have a lot of beefs with this, but the biggest beef that I personally and legally have with Ballot Measure 114 is this BS. You need to get a permit, a privilege to you granted by the state before you then get to go exercise a constitutional right. Obviously, that is one of the critical components of the Second Amendment challenge to this measure. Counsel correctly summarizes this problem as, the permits to purchase provisions of 114 violate the Second and 14th Amendments. The proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. And of course, it cites to the Bruin opinion. And this essentially is exactly the type of legislative scheme, in part, that was completely rejected, soundly rejected, by the United States Supreme Court in the matter of New York Pistol and Rifle Association v. Bruin. Now, counsel obviously wants remedy. All of this is great. You pointed out to us all the problems with the legislation. What exactly is the remedy that counsel wants? Plaintiff's counsel is because for every lawsuit, you have to understand, it's one thing to sue and say, okay, yes, you're right, all of this violates it. How do we fix the problem? That's what the remedy is, right? What is the fix to the problem? And plaintiff's counsel is asking for the following. A, enter a declaratory judgment under 208 U.S.C. section 2201 that 114 is unconstitutional on its face, or alternatively, to the extent its prohibitions apply to law-abiding adults seeking to acquire, use, or possess firearm magazines that are in common use by the American public for lawful purposes, because such prohibition infringes on the right of the people to keep and bear arms in violation of the Second and 14th Amendments to the United States Constitution. Because such prohibition infringes on the right of the people to keep and bear arms in violation of the Second and 14th Amendment to the United States Constitution, unconstitutionally takes property without compensation in violation of the Takings Clause, and arbitrarily deprives plaintiffs of protected property interest under Due Process Clause. B, issue an injunction immediately enjoining defendants and their officers, agents, and employees from enforcing 114 in its entirety, or, alternatively, To the extent that such can be segregated from the rest of 114, any provisions of 114 that prohibits the acquiring, using, or possessing of firearm magazines that are in common use by the American public for lawful purposes. So again, what Plaintiffs' Counsel is asking is the first remedy, stop the whole law from being enforced, rule it unconstitutional, and just kill it right now. In the alternative, however, if you're not willing to do that, the part about the magazine, which has an immediate impact on millions and millions of otherwise lawful and responsible Oregon residents, needs to be stopped immediately, and a temporary injunction needs to be placed on that. Listen, we will continue to follow this case. We have reached out to some of the Plaintiffs' Counsel. We're reaching out to some other organizations that may be interested in throwing their hat in the ring, and I do anticipate many more lawsuits that are going to try to stop 114 from going into effect, because right now, Oregon, if you don't get an injunction on this, this law becomes effective December 8th of this year. In the meantime, if any of you have any questions about what's left of your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.